Hello guys, and welcome to another episode of my lecture. This is Olayeni Dieko Daniels, popularly known as Dieko Spectre, and this is another episode of Dieko Talks Law. On today's episode of Dieko Talks Law, we will be looking at the 9th maxim of equity, that is Maxim 9, which says that equity looks at intent rather than form. Equity looks at intent rather than form. Now, before this 9th maxim, which is equity looks at intent rather than form, I have discussed the 8 maxims of equity. The first one being equity will not suffer a wrong without a remedy. The second one being equity follows the law. The third one being where there are equal equities, the law shall prevail. The fourth one being where the equities are equal, the first in time shall prevail. The fifth one being he who seeks equity must do equity. The sixth one being he who comes to equity must come with clean hands. The seventh one being equity avails the vigilant and not the indolent. The eighth one being equality is equity. And now this is the ninth one, which is equity looks at intent rather than form. If this is your first time of coming to my channel, I want to say a very big welcome. Thank you so much for visiting my channel. Please make sure that you click the subscribe button as well as the notification bell so that anytime I release a video which is going to be of interest to you like this one, it's very important that you click the subscribe button and the notification bell, so that you just get notified immediately I release a video. And also don't forget to follow me on LinkedIn at Dieko Daniels. Thank you so much. Now, going straight into our lecture for today, we'll be talking on equity looks at intent rather than form. So to our notes, a distinction is made between a matter of substance and a matter of form. Equity insists that what is important is the substance and not the form, and will therefore not allow a matter of form to defeat a matter of substance. Now, Romilly MR, in the case of Parkins versus Storrod, stated, which is very important, that the court of equity made a distinction in all cases between that which is a matter of substance and that which is a matter of form. And if it finds that by insisting on the form, the substance will be defeated, it will hold it to be inequitable to allow a person insist on such form and thereby defeat the substance. Are you listening to me? This maxim, equity looks at intent rather than form, is basically telling us that equity will look at the substance of a matter and not necessarily the form of the matter. Where it is that the form is likely to destroy the substance, then equity will step in and say, form, stay one side. What we are interested in here is the substance. During my internship, during my undergraduate days, I interned at a couple of firms as well as the Ministry of Justice of Lagos State. During one of my internships, I followed my principal to court, and it was a matter that had to do with land or something like that. So there was supposed to be an injunction. Are you listening? There was supposed to be an injunction. Someone came to court to come and stop somebody from doing something. Now, if that injunction is not granted, it means that that person will do it. Let's say demolition of land or demolition of house. The person was about to come and demolish the house. Then the person came with the injunction. My lord, please come and stop them from doing this thing. But I think there was something that was missing that the person did not do in that injunction. Maybe he didn't sign something. I can't really recall what it is that he did not do, but I know that he did not do something in that particular instance, and automatically, because you had not followed the procedure of what you are supposed to do, what the court is supposed to do on a normal day is throw your case out and say go and follow the procedure. But if the court does that, by the time it goes back, redraft, then come back to the court for the next adjourned date, they would have destroyed the house. Therefore, what is the essence? This is where equity is likely to step in. where according to what Romilly MR has said in the case of Parkins versus Toroid, he said that if it finds that by insisting on the form, the substance will be defeated. What is the essence of him coming to court on that day? To make sure that they do not what? They do not demolish the house, at least spending the time that they determine whether demolishing the house is the right thing to do. Do you understand? The court has to decide on that. Pending the time the court makes a decision on that, don't destroy the house. So that is the substance before the court on that very day. But because there is something in the form that is not correct, which the court ought to tell that party to go and redo, is going to be unequitable, because at the end of the day the substance will be defeated. The substance being the fact that the house would have been destroyed. That is one of the instances where equity will step in. Do you understand that? That is what Romilly MR is saying in the case of Parkins v. Toroid. This could be illustrated in two scenarios where you have time clauses in contracts and mortgages. So let us start with time clauses in contracts. If a party to a contract for sale of land fails to complete on the date stipulated in the agreement, at common law, it is a breach of a contract and the other party may repudiate the transaction. But in equity, time is generally not of the essence of the contract, and the breach of the time clause will not be ground for repudiation by the other party, provided that the party in question is ready and able to complete within a reasonable time. What are we saying here? Now, let us say that I am telling somebody, oh yeah, build my house for me. I am going to give you 5 years for you to build my house, and I will give you 50 million. I gave him 50 million, and after 5 years, I noticed that he has not done the decking of the house, that is the roof and all that, and he has not painted my house. Then I went to court. Under the common law, because I stipulated time that he was supposed to do it, and he has not done it in that time, this is what the court will say. The court will say that there has been a breach, and therefore there can be a repudiation. The moment there is a repudiation, that party is supposed to give me back my 50 million naira for the house, because the contract has broken down and there is a repudiation. Do you understand that? However, in equity will say no, that does not make any sense. Time generally is not essence of the contract, so the court will not allow that to happen in equity. What the court will do is that the court will call the other party, who is the contractor, and ask him, oh yeah, Oga, they gave you 5 years for the house, you have not completed the house, so what exactly is your plan here? My lord, please give me the next 6 months or the next 8 months, I will make sure I complete it. You sure say go complete them? Yes my lord, I will complete it. Granted. Specific performance, make sure you complete the house. Do you understand that? Equity looks at intent. The intent for the contract was the fact that 50 million was to be given to the contractor to build the house. The form is that the house was to be built in 5 years. If after 5 years the house is not built, equity will not repudiate the contract automatically. Equity will look at that intent and say no, it wasn't 5 years that was the intent. The intent itself is to build the house. 5 years is just the form. Therefore, we are going to focus on the intent, which is building the house, and overlook the form, because the form is going to defeat the substance. That is our intent. Do you understand that? So when it comes to time clauses in contract, the court of equity would always usually overlook it, as we can see in this case. Note that a plaintiff who is aggrieved by the defendant's failure to perform on time can sue for damages. In equity, specific performance could be ordered notwithstanding failure to perform the contract by the specified time. So this is it. A plaintiff who has been aggrieved, instead of you to repudiate the contract totally, which is what most of them usually do under the common law, what you can ask is, my lord, this is what I want to do. By 5 years I was planning to move into this house. This one that this person now has not built my house. My lord, please, I need damages. That damages is to look for a place to stay until this person is done with my house as he has contracted to. And in equity, you then ask for specific performance. That is it, that 8 months that he said, or 6 months he said he's going to get the house right. Let the court issue a decree of specific performance telling him to complete it in 8 months or in 6 months. While the court also, under the common law, let the court issue damages of so amount for not giving me my house as he had said that he would. Do you understand that? And then secondly, we go to mortgages. The maxim is also exemplified by Equity's attitude to redemption of mortgages. At common law, if the mortgagor failed to repay the loan on the date fixed by the mortgagee, he lost forever the right to redeem the property. Equity, however, always considered a mortgage to be mere security and regarded the provision for repayment on the day stated in the mortgage covenant to be mere formality. Equity thus allowed a mortgagor to redeem his property after the redemption date has passed. So under common law, this one is also as important. You should know that under common law, if I go and meet a bank today being the 23rd of April 2022, I go to meet a bank today, and then I tell the bank that I'm very broke and I want to do something, I want to do a business. Take my house. Are you listening to me? Give me 50 million. On this same day, 23rd of April 25, 3 years after now, 2025, I am going to come back and give you your money with an interest of 5 million, making it 55 million. Under the common law, on the 23rd of April 2025, that same day, if I don't give them back their 55 million, and then I am able to pay back 24th, that is a day after, I am able to, let us say that network no gree transfer, or let us say that something happened on that day and I'm not able to pay back the money, my house is gone forever, because you have passed the deadline. And when you pass the deadline under the common law, that is the end. But Equity said no. What is the substance of this agreement? Is it a purchase of house? No, now the house was meant only for security of a loan. In this case, it seems to me that this is more like purchase. This is not what is meant for. The substance of this agreement was that the house was not to be owned by the bank, but the house was to be used as a security for the loan. Therefore, if the guy cannot pay when his time has reached where he said that he's going to pay, we are not supposed to automatically convert it into a sale. We should still have something known as equitable time for redemption. Do you understand? Equitable right of redemption. And that is where equity comes in. Equity is looking at the intent. The intent for giving that house was not to sell it, but to use it as security for a loan. Therefore, the substance will be defeated if we look at the time where he was supposed to pay back, instead of us to be looking at what exactly he was supposed to use that house for. Do you understand that? So that is where equity seems to want to step in and say, no, that is very wrong. Equity thus allowed the mortgagor to redeem his property after the redemption period has passed. Can you see that? However, that's subject to certain conditions, but still equity will step in. So, but equity regards time to be of essence in these two cases. Number one, where expressly agreed by the parties that time will be of the essence. So this is what lawyers usually do. This is the reason, lawyers are very smart. When they are drafting a contract, they will make sure they slot it in there that time is of the essence in relation to this contract, so that when the other party doesn't do what he's supposed to do, they can just go for a breach of contract. And then you not come and say, no, my lord, is this, is that, and then the other party says, I'm gonna go to article 25 sub AI. They will chuck it somewhere. What does it say there? it says that time will be of the essence of this contract, and therefore if you do not do this and this and this by 25th, it will be deemed to be a breach of contract. So what are you now saying now? Lawyers are very smart people. So we are expressly agreed that the time should be of essence of the contract, then Eqiuty will not step in. Eqiuty will not. Eqiuty will say, yes, since you agreed to it, I'm not going to do anything here. And then number two, when the nature of the property so requires, as stated in the case of lock and bell, where it is that time should be of the essence of the contract. For example, during one of my lectures, I discussed about Davido going for O2 Arena concert, and then he said that one musician should come and do something for him, or one person should come and help him with the planning of the stage planning. So obviously, as you can see, time is of the essence of that contract, because there is already a stipulated date for that concert, right? And people have bought tickets. Therefore, if he fails to show, he can sue him for breach, sue him for damages, sue him for a lot of things for not coming on that day. And there's nothing Eqiuty will do for you, because time is of the essence. Eqiuty cannot say, oh yeah, go and when everything has passed. Do you understand what I'm saying? If that show later flops and Davido had to pay some people back their money, he can collect that money from the person for not fulfilling the terms of his contract. Do you understand? Because in that case, time is of the essence, and that is the case of Lock v. Bell. And also we can see other cases of Mustafa v. SCOA 1995-21 NLR. We can see the case of George versus Fajore 15 NLR. We can see the case of Jojo versus Cole, Balogun and Balogun, Benwaro versus Onwunchilewa. And that is where we are going to end our lecture for today. Thank you so much for watching to the end of this lecture and listening to the end of this lecture. Please make sure that you click the subscribe button. Make sure you like the video. Most importantly, make sure that you click the notification bell and share with your friends. My next Maxim is going to be on Eqiuty regards that has done what ought to be done. And I will see you in my next class.